Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic is rent control nightmare. They won't even let you move into your own home. Well, hello, everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio coming at you every Saturday at 3 p.m. For those people who are watching live, the first song I played was Happy Together. It was originally performed by the Turtles and released in 1976. Now, the inside story was that it was written by two songwriters by the name of Gary Bonner and Alan Gordon, and they had shopped this song to many artists, and it was rejected. Finally, it was viewed by the Turtles, who weren't really enthusiastically in favor of the song. However, their producer, whose name was Joe Weissart, convinced them, and of course, it became a monster hit. Now, if you're looking for this song on Pandora, you're probably not going to find it. And that's because there continues to be an ongoing copyright dispute between the writers of the song, and their company was called Flo and Eddie Inc., and the streaming services that have played it. And in fact, Flo and Eddie Inc. Did win it in many courts, this copyright infringement case, but they lost in California. So many of the streaming services just do not want to have that song on there. But I found it anyway. And in case you're also curious, if you were listening live, the second song was by Elvis Presley, and it was called Suspicious Minds. Let's talk about the show format. There's an opening topic. And then after the opening topic, I'm going to open it up to questions and answers for those people who are in the Zoom meeting. And if you do want to ask a question, please electronically raise your hand. You can do that now, and you'll be sure that I will call on you within the time constraints of our show, which is 1 hour. And if you are watching it on YouTube, please hit that like button and subscribe to my channel, because it really helps me on that situation. So let's open it up to that topic. And what is the topic? The topic today is rent control nightmare. I can't even move into my own home. How is that possible? Well, let me start by telling you a couple of stories. And both of these were dealing with clients of my office. The first one was a few years ago. My client's daughter was admitted to USC, and the father thought that in terms of investment purposes, it would be smart to buy a duplex in the USC area. His daughter would move into one of those units and, of course, rent out the other. And then by the time that she graduates 4 years later, there'd be a pretty good appreciation value. So this was a very good economic plan that this father had. And of course, he paid his down payment, made his mortgage payment, paid his property taxes. But what he didn't do is do a little bit of due diligence, because you see, this property is located in the city of Los Angeles, and this property was under rent control. And while in fact, under rent control, you can't ask a tenant to move because you want to put in a close family member like a daughter, there are exceptions. So what are the exceptions? And this one exception is that if the tenant who's occupying the unit is 62 years of age or older, or handicapped, and has lived there more than 10 years, well, that tenant is exempt from being asked to move because you want to put in a close family member. Well, you see, the problem was both of those units were occupied, and both of them were occupied by people who were over 62 and had lived there for 10 years, which means that the entire reason for buying this duplex was totally frustrated by the people who run the city of Los Angeles, who are just usurping our property rights, where a person who owns property can't even move into his own unit. And there was another situation which occurred recently where one of my client's houses was the subject of the fires that occurred, and his house was totally lost. Well, he had another house, which was tenant occupied. But because of the rules dealing with statewide rent control, which we're going to get into, he couldn't ask that tenant in his own house to move, even though he was displaced by the fires. Again, this is just a trampling of our property rights, where the most basic property right I can imagine would be to buy a piece of property and then I can't personally occupy it. Okay? So let's go over what the statutes state uh, for California. And there's a few that we're going to talk about. The first one is we're going to talk about the statewide rent control. That's Tenant Protection Act, and that's under AB 1482. That was initiated in the year 2019. Now, is your property subject to statewide rent control? Well, the first issue is if your property is subject to a local statute, rent control statute, then you are exempt from statewide rent control. But of course, you'd be subject to that you'd be subject to that local rent control. So if your property is not subject to a local rent control, then you possibly are subject to statewide rent control. There are some exceptions. So what are the exceptions? If it's a single family home, a townhouse, or a condominium, then you are exempt from statewide rent control. But if you are exempt from statewide rent control and you're not subject to a local, well, then you don't need a reason. You could just serve that tenant who's on a month-to-month tenancy a 30-day notice to vacate if they've been there 1 year or less, or a 60-day notice to vacate if they've been there longer than 1 year. You don't need a reason. It doesn't matter who's moving in or what you want it for, as long as the tenant is on a month-to-month tenancy. But you don't get this exemption, that is for a single family home, a townhouse, or a condominium, unless you have in your lease, which was entered into from November 1st, 2020 and forward in time, you have to have a phrase in your rental agreement that states this property is exempt from statewide rent control. If that phrase is not in your rental agreement, any rental agreement that was entered into from November 1st, 2020 forward in time, then you are subject to statewide rent control, and you're going to have to comply with the rules in terms of evicting the tenant to put in a close family member. Now, I might add that if you go to my website, which is evict123.com, and go to the free form section, I have a lease that is in total compliance with all of California laws. I suggest that you use it. And contained in that lease, there's a couple of boxes to check. One that says that it is exempt from statewide rent control, or that it is subject to statewide rent control. Well, if you have a townhouse, a condominium, or a single family residence with only one house on the lot, you definitely check the box, and therefore you're not subject to statewide rent control. So if a tenant's on a month-to-month tenancy, then you don't have to worry about terminating that tenancy. You don't need a reason. Also, if your property for statewide rent control was built within the last 15 years, again, you do not need cause to evict. But let's state that now my property is subject to statewide rent control. Well, then you have to have good cause to evict. Well, good cause is that you want yourself to move in to occupy your own property, or a close family member. Now, there are specific close family members that you are allowed to move in. That would be your grandparents, your parents, yourself, your spouse or domestic partner, your children, or your grandchildren. Those are the only persons permitted under good cause to have yourself or a family member move in. So for example, if you want your brother to move in, forget about it. He can't move in unless you put him on title as an owner. Otherwise, you can't have your brother move in. But you see, again, for statewide rent control, if you entered into this lease, and no one knows this, by the way, if you entered into this lease as of July 1st, 2020, forward in time, July 1st, 2020, you have to have a phrase in your rental agreement acknowledging to the tenant that they might be evicted in the future to put in a close family member. Now, again, this phrase is dramatically put into my rental agreement, which is online. And I'm going to read you what that phrase says. It says, the owner may terminate this tenancy if the owner or their spouse, domestic partner, children, grandchildren, parents, or grandparent unilaterally decide to occupy the residential unit. But if this rental agreement was commenced as of July 1st, 2020, or thereafter, and you didn't have that phrase in your contract, you can't put your own grandchild into that house, which is otherwise exempt from statewide rent control, unless that phrase was there. Or even if you have an apartment house, which is of course subject to statewide rent control, which would be older than 15 years, if that phrase is not in your rental agreement, you can't have a son, a daughter, a grandparent, a grandchild move in because you didn't put that phrase in your rental agreement. This literally is insane, okay? When you do have that phrase in your rental agreement, you have to serve a specific notice to vacate, normally a 60-day notice. You have to state who's going to be moving in, the name, what relation that is to the owner of the property. And it also has to state special language that if the tenant wants proof as to the relation, then the landlord will give it to them. That has to be stated there. Now, also under statewide rent control, you have to pay relocation money. That relocation money is 1 month's rent for any property subject to statewide rent control where you want a close family member, which I've described. You have to pay them relocation of 1 month's rent. You can either give them the money directly or you can use it a credit during that 60-day period that they're remaining in possession where you'll waive the rent for that 1 month period. Now, the law states that if you ask a tenant to move under statewide rent control, then you have to move in, that relative has to move in, or you have to move in within 90 days, and you have to remain on the property for at least 12 months. If you move out earlier, you might be the subject of a wrongful eviction. Okay? Okay, let's move on to the city of Los Angeles. If you think statewide rent control is bad, you have no idea with regard to the city of Los Angeles, okay? So what do we have for the city of Los Angeles? And that is that, again, you have to have that same class of relatives, close family members, once again, yourself or grandparents, parents, yourself, spouse, domestic partner, children or grandchildren. But as I said in my example, with regard to that father that bought the duplex, if you have a tenant who's over 62 and or handicapped and has lived there 10 years, that tenant's exempt, okay? But Los Angeles goes on and has another requirement. And I'll give it to you this way. Let's pretend you have a duplex where one tenant has lived there for 15 years, but he's only 55. And you have another tenant that moved in 1 year ago, but he's on month to month now. Now you can imagine in the city of Los Angeles that the rent for those two units would dramatically be different. Obviously, the person who recently moved in, his rent is going to be much higher than the person who's been there for 15 years, who's been protected under rent control. So logic would state, if they're both a two-bedroom unit in this duplex, logic would state that you'd want to pick the tenant who's been there the longest. Because why should I put my daughter or close family member into a higher unit where the rent I'm getting good money for versus a unit where the rent is very low? So logic would state that you would pick the tenant who's been there the longest period of time. But there's nothing logical about these laws. The city of Los Angeles has a rule called last in, first out. Last in, first out, which means you have to take the tenant who's paying the most rent. And if you don't, okay, then you have no right to ask that tenant to move. The last in, first out. Now, let's pretend there was a 3-bedroom unit and a 2-bedroom unit. Well, it's by like unit. So since there's only one 3-bedroom unit, if you wanted your son or grandparent to move in, you could pick that one. as long as it was an exempt tenant by their status, even though that person moved in before, because they're different units. But if they're the same amount of bedrooms, like a one bedroom, they're each one bedroom, you got to take the last one in. Now, the city of Los Angeles requires that you pay relocation. So let's talk about what that relocation is. I'm going to share my screen now, which I have up. And you're going to see what that relocation is. And it's staggering, ladies and gentlemen. The relocation, if a tenant's been there longer than 3 years, as my chart shows, and is a qualified tenant. A qualified tenant is a tenant who's over 62, but not been there longer than 10 years, or is handicapped, or has minor children. You've got to pay this tenant $25,700 to move. Now, they do have a mom and pop exception. If you own 4 units or less in the city of Los Angeles, then it would drop down to $19,950. If this is a single family home, I'm not talking condos, but a single family home, then it's only 1 month's rent. But if I have a duplex and I'm asking this tenant to move, and I have the right to ask him to move, and he's been there longer than 3 years, and there's minor children in that unit, I have to pay this person $25,700. Where are my rights as a property owner? This tenant is on a month-to-month tenancy. If this tenant wants to move, all he has to do is serve a 30-day notice. That's it. He doesn't have to do anything else. But if I want him to move, because I want my own grandchild to move into my own unit where I paid property taxes to the county of Los Angeles and pay my taxes to the federal government, I have to pay this person $25,700 to move. This is literally insane. But that's what we're faced with, okay? Now, under the rules for the city of Los Angeles, the close family member has to reside in the unit for 2 years. If you move out before those 2 years, you have to offer it back to the same tenant for the same rent that he was paying. But it gets more insidious. What if you stay there for 2 years and then legitimately you want to move out? So now the unit is vacant. And of course, you'd be able to raise that rent for any new tenant coming in to market value. At least that's what you think, but that's not what the law is. The law states that you have to rent that same unit that you've lived in since you've evicted that tenant to live in it yourself. And let's pretend you've lived there now for 4 years. When you move out, you have to re-rent that premise to the next tenant coming in for the same rent as that displaced tenant was paying, plus any applicable increases that the city allowed for the next 4 years. This is such a trampling of property rights. Let's move on to the unincorporated areas of LA County. Of course, they have the similar rules of who can move in, those close family members only. They have the same rules that you have last in, first out. Of course, they've got the same rules, but they have their own relocation as well. And I'm going to show you their chart. There's their chart where you can see if it's a 2-bedroom unit, for example, and you're asking this tenant to move, you're going to need to pay him $15,921 for the privilege of moving into your own apartment or own house. See, on LA City, if it's a house, it's only 1 month's rent. This, it doesn't matter. If this is a 3 or a 4, let's pretend a 4-bedroom house, you're going to need to pay this person $21,411. But it gets worse for the city, for unincorporated areas of LA County. And you're thinking, how could it get worse? Well, not only do you have to pay that $21,000 relocation to the tenant, you have to hire a relocation specialist. Now, I know what you're thinking. What the hell is a relocation specialist? Well, this is a company that you have to contract with who will then interact with your tenant and help them move. incredible. And if you call up LA County is the only one who does this. If you call up LA County and say, okay, close family members moving in, I'm prepared to pay the relocation, and I'm prepared to pay and hire a relocation specialist to assist my tenant in finding another place. So, LA County, could you refer me to a company? We have no referrals. Well, what do you mean? Where do I find this relocation specialist? We have no idea. We can't give any referrals. But you're telling me under the law that I have to have one. You would think you'd see one. Sorry, we don't know any, we don't give any referrals, which means that you're forced to go out and try to find one. Well, my firm has found one and one only, which if you do call my office and I'll give them to you. And when I called them, tried to get a deal for my client, they were totally unreceptive. They charged $3,000 on a retainer, and then it goes on an hourly. And God knows what the hell they're doing. But in order to proceed forward with a family member move-in for unincorporated areas of LA County, you have to show the contract that you entered into with this relocation specialist. It is such a trampling of property rights. This is for legitimate people who own property. What a basic right that you want to move into your own property. And these are the hoops that you have to go through. So this concludes my topic on the rent control nightmare. I can't even move into my own house. Well, we're going to open it up now to questions and answers. Again, if you are in the Zoom meeting, please electronically raise your hand and I will call on you. If you are watching on YouTube, then I would ask you to please hit the like button and subscribe to my channel. The rules for the questions and answers are these, and that is that this broadcast is for informational purposes only. It is not a substitute for legal advice. If you want to talk to me and you're in the Zoom meeting, please electronically raise your hand. This forum is for general questions only. If you do have a case with my office, I don't want to discuss it on air, please call my office and we'll be happy to answer it. And last but not least, it makes it much more enjoyable that if you do have a camera, please leave it on while you're talking to me because it does make it much more enjoyable for myself and for the audience. And with that, we're going to go to our favorite regular who's known the world over, because I heard that at the last meeting when I did LA Convention Center, and that is
Yeah.
Jim Molina. I think I'm going to have to make you like co-host of the show. How are you today, sir?
Oh, good, Dennis. Good to see you.
And good.
Well, pretty wild stuff, man. Pretty wild stuff. I applaud you for trumpeting the injustice that's going on here. Keep it up. All righty. So the qualified tenants that you had were 62 and older, handicap, and I understand any family with minors qualifies. Any children.
Correct. If they have children, then that becomes a qualified tenant, and that
Wow.
means you're going to pay the higher amount. Okay, so for example, in the city of Los Angeles, if they've been there longer than 3 years and the person who's wants to move in doesn't qualify as a mom and pop owner, that is an owner that owns 4 units or less in the city of Los Angeles, then the relocation is $25,700.
Crazy, crazy, crazy. Well, as you know, I'm in San Luis Obispo, so we don't have the LA city or county requirements. But AB 1482, statewide rent control, does it have any of that kind of stuff in it?
No, it's just 1 month's rent only, and they don't have the last in, first out rule, but it's only 1 month's rent only.
Okay. Okay. Super. Good job, Dennis. Thank you.
Thank you, sir. We are moving on to Ro. How are you? Please unmute yourself.
Hi, yes, thank you. I have two questions. Under the Just Cause Ordinance, I have several residential homes, and they sent me the forms for probably four of them. and 4 I haven't received. Now, should I just wait for them to send it or should I call and be asking for it? I filled out the ones they sent me. I sent it in, but there are more that they did not send me.
These other homes are all rented, correct?
They're all rented and single
Yeah.
family
I
homes.
I wouldn't wait for them because then they'll fine you because it is what the law is, and the law says that you have to register your units. You already have your statement number, which you need to register your units because it goes for all your units. So I would definitely register every unit, and as you know, you have to pay a registration fee, which I've talked about on previous shows, of $31.05, and this is just a total money grab by Karen Bass and the other hooligans that sit on the city council for Los Angeles.
So you're saying I should contact them to get the rest of the houses registered?
It's not a matter of contacting them. You've registered some, so you have a registration login. Go to your registration login and just add these other homes onto it.
Oh, okay. And just to clarify, so I am not under rent control, so I can raise the rent as much as I want. Is that correct?
And that is correct. Since it's a single family home under the Costa-Hawkins Rental Housing Act, you can raise the rent as much as you like, whenever you like. However, if you're raising it more than 10% in any 1 year period, you need to serve a 90-day notice.
Oh, okay. All right. Thank you very much.
And thank you. Okay. Moving on to Julia. How are you? I'm letting you unmute yourself, please.
Okay, got it. Thank you. How are you?
I am good, thank you, except
Good.
for yesterday's game.
I know.
But we're not
Heartbreaking
going to
loss.
talk about that
No.
tomorrow.
Um, as always, thank you for everything you do. We certainly appreciate it. So my question this week is, um, I'm having my property is a 4 unit in the city of Inglewood. And so I'm having an inspection this week by the city for an electrical job that we did, and we touched each of the units. Okay. And so I want to give them a notice that we'll be coming in. This inspection is scheduled for next week. So I want to give them a notice to say we're going to come in because the city, needs to, verify the job. But right now, they've only given us a window from 8 to 4. Is that sufficient on the entry notice? Just say we're coming in this date, between the hours of 8 and 4. I don't know
Yes, I
how
mean,
long that.
normally if you're going to, let's say, have a plumber come, you should give it the time when you expect the plumber to be there.
Right.
However, since you're dealing with the city and their official from building department, then you want to say that the person from building and safety will be coming in to inspect the electrical work that was done, and the time that he'll be coming in is anywhere between the hours of 9 a.m. to 4 p.m., for example.
9 a.m. to 4 p.m. Okay. All right. Also, too, the contractor that I'm working with has asked if we could not have the tenants there. He doesn't want any conflict or conversation, between the tenants and them. Is there any control that we have over that?
You have no control over that. It's a nice position by the contractor so that the job and the inspection goes smoothly. You don't want any interference from the tenants, but you have no basis of asking the tenants not to be there during this inspection period.
Okay. All right. And so just saying we're coming in between 9 and 4, that's fine.
You got it.
Okay.
Spell it,
Thank you.
spell it out as to the reasons you're going in and that the
Okay.
inspector from the city of Inglewood will be there.
Okay. Thank you.
Kevin Davis, how are you today, sir?
I'm good, buddy. Getting emails from AOA and local brokers talking about AB 1157, saying it's going to affect our ability to increase rents on single families. Is that correct?
I'm not familiar with that bill. Normally, I don't get to review these bills unless they actually become the law. It would
Okay.
fly in the face for example, of the Costa-Hawkins Rental Housing Act, which that bill, which has been around since 1995, and they tried to revoke it on the last election, but failed miserably. That bill starts that notwithstanding any other law, you have the right to raise rents on condominium, single-family homes, or townhouses without limitation. So I don't know how they would get around that. So it's dubious that anything else would pass would really impact your ability to raise rents on a single-family home, for example.
Their argument is that since it's not a local, like a city law, it would be a statewide law, that's how they're going to get around it. Does that make any sense to you?
No, because Costa-Hawkins is a statewide law, and it
Yeah.
starts out notwithstanding any other law. So how are they going to get around that? The state legislature would have to repeal that law first before they entered into another law. So I don't see how they get around it. So you've got a lot of yahoos in our state legislature who will just pass anything as long as it's detrimental to property owners.
Yeah. Okay. All right. That's what I wanted to hear. Thank you, sir.
All right. Thank you, Kevin. Betsy, how are you today on a Saturday?
Hi, thank you very much, Mr. Block. I got one question. Let's say I'm in unincorporated LA County. Let's say I raise the rent. Then the tenant brought their parents in. Can I raise another $100 each per person?
No, the County of Los Angeles for unincorporated areas does not have that as a provision. That is in the city of Los Angeles. You're entitled to a 10% rent increase for extra people moving in as long as you did the rent increase within the first 60 days and the first minor child is free. But that's not true in unincorporated areas of LA County. But you have a better remedy, and that is if they brought in additional people in violation of the rental agreement, you have the right to demand that they move out by serving a 3-day, actually it would be a 10-day notice for the county. And if they don't move out within the 10 days, then you have the right to evict everyone from the unit. And when you do, you get to raise the rent to market value.
Okay, then. Okay, thank you.
You're very welcome. And we're moving on to Tessie. How are you? Tessie, are you there? Okay, we gave you a chance. Okay, moving on to Austin. How are you, sir?
Very good, Dennis. Thank you for another edition of Landlord Tenant Talk Radio. Can you hear me okay?
Perfectly.
Oh, very good. Okay, so my question is, with owner occupying, if you have a lease agreement after July of 2020 and the lease agreement does not have the owner occupancy verbiage, can you still owner occupy that house using a change of terms of tenancy, or does it have to be a signed addendum? And this would be specifically property subject to statewide rent control only.
Again, it has to be contained in the rental agreement. You can't do a change of terms of tenancy. You could have the tenant either sign an addendum or sign a brand new rental agreement. Again, that phrase is in my rental agreement, and very few of even like the California Association of Realtor forms don't have that phrase in. They need to put it in immediately because people are just unsuspecting. And you rent out a property, and then what, 4 or 5 years later, hey, you know what? My kid wants to move, and this would be perfect. You don't have the right to ask them. I mean, it's insanity the way this law was written.
Yeah, I guess I've seen. I guess my understanding is any lease entered in before July 2020, it's not required to have that language, correct?
That is correct, because the law didn't exist. So if you had a lease that was entered into in 1997, obviously it wouldn't have had that included in with it.
Right. I've seen when I was purchasing property, I saw a lot of leases that were entered in 2021, 22, 23, and they didn't have that language in it. And it was a lot of realtors didn't understand that. So when I would tell them, hey, yeah, this is not a good, house hacking opportunity for an investor like me or an owner occupied strategy, they didn't really have a clue. But now that you explain, the details of SB 567, it makes all the sense in the world now. So thank you.
And thank you, Austin. Appreciate the input. We're moving on to Bryant. I'm going to ask you to unmute yourself. Mr. Bryant, are you there?
Oh,
There he goes.
you're good.
Hello?
Hey, Dennis, can you hear me?
I can.
Yay, cool. Well, let me check the video here. Great, great. We recently purchased a place out in Huntington Beach, and we have one. It's in a one bedroom, and we have one of the tenants. They're causing a little bit of an issue in terms of she's complaining with the other about other tenants, and some of the tenants it's creating a little bit of rift. And we want to know what options we have to invite them to leave. They're on the mature side. They're closer to they're at least 60 something, and then we think she may be a few marbles short, perhaps. There are a couple, husband and wife there, and we're thinking like we'd like to invite them to leave because it's kind of affecting the other tenants. One tenant's already proposing, "Hey, I want to get out because it's not safe because she's always yelling, she's being combative, uses foul language." And we just bought the place and we kind of updated the leases, and we told everybody, "Hey, we want a safe place, we want to do this, we want to do that," and all the tenants are, "Hey, this is great except for this one. It's only a quadplex." And she's been this one person. She's been pretty aggressive with some of the tenants. We want to know
Okay,
what
well,
options do we have.
let me slow you down a little bit. What city again was this?
Huntington Beach.
Okay, so Huntington Beach, so you are under statewide rent control because I presume the property was built more than 15 years ago, correct?
Yeah, correct. Yes.
Okay, so she's on a month-to-month tenancy and they're fighting. So are the other three units complaining about this unit?
Yes, correct.
Okay, and the complaints are that there's excessive noise and that she's being combative. How is she being combative with other tenants?
She has threatened them. She has complained about them, called the police on them for no apparent reason, and accused them of spying on her and listening in on her conversation
Right.
and throwing pebbles at her door.
At her window. Yeah.
The tenant threw pebbles at another resident's door?
Window. Yeah.
Window and
All
door.
right, well,
The
then
window.
that's just grounds for eviction right now. What we would do is we would serve a 3-day notice to quit based on nuisance and then proceed forward with an eviction. The only negative part of that is that I do need to have the cooperation of other tenants. In a small percentage of cases, I would need their participation, where if worse came to worse, they would have to come to court. So you might want to check with them if they're willing to testify. Again, it's a very small percentage. Usually I don't need them at all, but it can push come to the shove. So we could then serve on that tenant a 3-day notice to quit. You're not to take any further rent from these tenants. And then after the 3rd day, we then bring forth an unlawful detainer to evict them. If they're throwing rocks at a window and we've got the constant noise and being combative with other tenants, that constitutes a nuisance, and the other tenants don't have to deal with that.
Let me clarify. The person in that one unit is saying that other tenants are throwing it on her window.
Oh, okay. Well,
Yeah.
but again, if they're complaining about the noise and you've obviously warned this tenant, I presume.
No, actually, we haven't. Because
All right, well, then the first thing is to send them a letter before we get involved in an eviction lawsuit. Send them a letter and saying, we're getting complaints from other tenants about these items, and list every one. If this happens again, I will bring forth an eviction. And that's what you need to do.
Okay.
Do we need video evidence?
No, you just need people with a mouth and 2 eyes who can come to court and testify.
Gotcha.
Okay.
All right,
Thank you.
Thank you.
Thanks.
Thank you. Moving along to David Azran. I'm going to ask you to unmute yourself.
Hey, Dennis, how are you today?
I am good, thank you.
Good. Thank you again for doing this. We all really appreciate it. Couple of quick questions. Number one has to do with this new anti-gouging legislation. Apparently on February 4th, 2025, Governor Newsom issued Executive Order N-17-25, which in conjunction with Penal Code number
396.
limits the amount of rental increase due to the fires statewide to 10%.
Okay, it's not statewide. It's only for the county of Los Angeles, because
Okay.
that's the one that was impacted by the fires. And basically what his emergency order says, that if he's declared an emergency, which by the way is going to be off as of July 6th, 2025, because that's when the 6 months is up, then technically you can't rent gouge. That is charge more rent. Now, there's a couple ways to look at this. Number one, if you have a single family home that you are advertising, let's pretend for $10,000, and then you didn't get any takers, but now since the fire, you're now advertising for $15,000, that could be considered to fly in the face of that statute and subject yourself to, quote, this criminal penal code 396. However, if I had a tenant in a house where I can now raise the rent to whatever I like under Costa-Hawkins, and that tenant moves, we're getting a lot of noise from realty groups that you can't raise the rent more than 10% or 150% of the average mean value for that. And that's all hogwash. If I have a vacant unit and a tenant moves, I can rent that unit for whatever I want, okay? If I did list it for one price and then because of the fires, then I would have a problem with that, even though I still think you can legally do it. But certainly, if a unit becomes vacant, I can rent that unit out for whatever I want. And again, it goes back to the Costa-Hawkins Rental Housing Act, enacted in 1995, which starts with the phrase, notwithstanding any other law, for a single family home, a townhouse, or a condominium, I can raise the rent to whatever I like. It also states that if I have a unit that becomes vacant, that I can again establish that rent. So I don't really care what Governor Newsom did in terms of declaring a state of emergency and stating that by the way, 16,000 homes were impacted. 16,000 homes and businesses were impacted. There are 2.6 million businesses and homes in the county of Los Angeles. So the percentage of houses, while it was a horrific event and no one's not going to say it, is so infinitesimally small, and the overreach by declaring this state of emergency and then talking about rent gouging is beyond belief. But notwithstanding that, if you have a house, I'm on firm footing based on Costa-Hawkins that if it becomes vacant, you can rent the house for whatever the hell you want. But right now, if you're going to raise rents, even on existing tenants, you have to serve a 90-day notice. If you do it now, it's not going to take effect until at least August 1st. So that's beyond the July rate anyway. So I don't see that as a problem, David.
Yeah, my situation falls within that window. So tenant number one is vacating the middle of June. And so now we're on the cusp of that July 6th cutoff. Strategically, is it better to just wait until, say, July 7th to make the property available?
If you're faint of heart, then you should do that since it's so close. However, I don't see any problem with you renting it out immediately.
Okay. Second question, security deposit. And as I'm sure you're aware, 1 month is just not enough. I mean, as far as the real world, and if the tenant decides they're going to stop paying rent, clearly it takes longer than 30 days to get them out. That's before we talk about damage. So I believe the statute reads that if for a single family home, if the owner has, is it 2 or more properties? Then they're
It's 2
subject to that
properties
statute.
with a total of 4 units existing in those 2 properties. So if I have, for example, a triplex and a single family home, then you can get 2 months security deposit. If I've got 2 fourplexes, then technically I couldn't. But if I put one of those fourplexes into an LLC, then there's 2 separate owners. And if there's 2 separate owners, then I could get, for example, a double security deposit, a security deposit equal to 2 months rent. There's another thing that you can do, and that is in the state of California, you can charge advanced rent as long as you're charging 6 months to 1 year in advance. So if you have a tenant that has some money and you can get that 1 month security only because you have an 8-unit building and a single family home, you could go and say to the tenant, look, I'll let you move in, but you got to pay me at least 6 months rent. So you'll get 6 months rent in advance to ensure compliance with that they're going to meet the terms of their rental agreement and get that 1 month's rent. So that's another way around it.
That does sound good. Because so for an LLC with 3 properties in it, single family homes, then we're stuck. I think condos, townhouse, but single family.
You're stuck because it's three separate
Yeah.
properties.
Yeah.
So put one in a LLC and leave the other in a different LLC, then you're fine.
Right. Then you take the hit of the 800 every year for the state.
Absolutely.
You know, they always coming and going, they get you.
It's unbelievable, the assault on income property owners. Thank you very much, David. Good questions. We're moving on to Janice. And Janice, I've been looking for you, and do you know why?
Because you wanted to answer my question from 3
That
weeks.
is true. And I was waiting for you to come back.
That I was in California fighting off the critters on my property. The moles, the termites, you got a lot of critters in California, Dennis.
Oh, they do. But they got their fair share of rats in New York where you're
Yeah, we
sitting
have
right
only
now.
rats and roaches. We don't have all these other
And
things.
you're referring to the politicians, correct?
Yeah, those as well, right.
So in any event, Janice asked a question about bicycles that are motorized or even mobility equipments that are motorized, like a scooter or something. And so I took a look at the law on that. Number one, if you have a non-motorized bicycle, you can definitely store that within a unit. If you're bringing in a motorized bicycle, an e-bike, or a motorized like cart that people who have a disability need to sit in a cart and roll around, and it's obviously electrified, then it has to have certain qualifications under the code, which if you go to my website, evict123.com, and go to the freeform section and take a look at my lease, I have the electrical qualifications that are required for that mobility or electric device, electric bike. So each person who's in the unit has the right to have either one bike or one electrified mobility device. But it has to meet those electrical standards. And if you want to see exactly what they are, just go to my website and look at that term in my rental agreement.
Here in New York, with their constant deaths and building destruction from e-bikes, and I'm wondering, even if the tenants say they don't have any, am I legally required to have that addendum in the lease that's ask them to fill it out or
you
not?
don't need the addendum in the lease, okay? But
Mhm.
that's just what the law is with regard to e-bikes, okay?
I thought it had something to do with the garage. You had to have the garage wired especially for e-bikes, which I don't want to do.
Yeah, no, they're talking about moving bikes into your
Inside.
apartment, and they have to meet certain safety standards. One is, I'm looking at it now because I called it my lease, the UL 2849 standard for electrical e-bikes. And that's by the United States Consumer Product Safety Commission. And there's a bunch there. You just want to make sure that when you're purchasing, or if you're the landlord looking at the bike, that it's stamped on the bike, that it's in compliance.
Okay, thank you.
And thank you. I didn't forget you, Janice. You see that? Moving on to Harold Rhodes. How was that pool today?
It's nice. It's nice.
Wait, it's raining, Harold. So
Not
why
where
are
I'm
you
at.
fun?
It's sunny where I'm at right now.
Okay.
I'm in Woodland Hills towards Calabasas, where you live.
Yes, sir.
Okay, so 5 years ago, I had this tenant fill out a contract, and I'm wondering, at the time it was like first and last plus a $200 security deposit. And I since have heard your show saying, hey, you can't do it that way. Since I did it not correctly, does that void the contract, or that one piece is
No,
voided?
the last month's rent, which should never call it a last month's rent. It can only be called a security deposit. That last month's rent is just considered a security deposit. However, if the tenant gave you 30 days notice on May 1st that they were vacating, you'd be duty bound to use that last month's rent, so he wouldn't have to pay you rent. So it's never to your advantage to call it a last month's rent. It just call it a security deposit. But now you're limited, of course, unless you hit the exemption to only 1 month's rent.
So what basically it was first, last, and $200 security is what I said. So what is the interpretation of the contract I created?
Right now, you have a security deposit equal to 1 month's rent plus $200.
Okay, got it. So I'm still good. It's just I screwed up originally.
Yeah,
Okay, cool, man. Go Lakers.
tomorrow. All right, moving on to, I have an iPhone. I'm going to ask you to unmute yourself.
Good afternoon, Dennis. How are you?
I am fine, thank you. Oh, by the way, Tess, if you're still out there, I think you got your microphone going. If you electronically raise your hand, I'll call on you next. But go ahead, sir.
Yes, Dennis. I have kind of like a unique situation. I never heard any of you talked about it on your show before, but I had a tenant about a year and a half ago, about a year and 3 months ago, that we successfully evicted. In that particular case, there were some issues with the 3-day notice, but for some reason, the judge still allowed the eviction to proceed, and the tenant was eventually evicted. The tenant appealed that eviction through this, I think it's called the Second Appellate Court, because it was an unlimited case, and the court reversed the judgment. What happens? I mean, a situation like that, since
Well,
the
you
tenant has
certainly don't
already
have to
been
put the
evicted.
tenant back in possession. I mean, you already have possession. There's no going back on that. So right now, he
Okay.
might be able to get court costs on that. He might be able to get attorney's fees based on the terms of your contract, but that's about it. Uh,
Mm-hmm.
and you also have the right to sue him, like in small claims court, because you got a judgment for the rent owed, I presume, and that was vacated. But that doesn't mean that he doesn't owe you the rent. So you have the right to sue him in small claims court.
Okay, so even because I know I had an attorney sent a letter or something, and they said something about the tenant may be suing for wrongful eviction. I'm not sure how that works. Is
That
that
could have
considered
never
wrongful eviction
happened.
if the
Yeah, that would not happen. It wasn't wrongfully evicted. You went to a court of
okay.
law and the judge ruled on your side. When you talk about wrongful eviction, that means that there was some malicious intent, that there was no basis. Clearly, there was a basis. The judge ruled in your favor. So that would be a case that could be dispensed with quickly. And that's
Okay,
an
thank
attorney looking for a money grab, by the way.
okay. All right. Thank you so much.
Good question. We are moving on to let's move on to LKJLC. Ask you to unmute yourself.
Hi, Dennis. Been a long time listener, and I'm really sorry about the Lakers yesterday, but got a question that's similar in line to Mr. iPhone just previously. I had a tenant that I had evicted for non-payment of rent, and they were behind about $10,000 in rent. It was rent for more than 1 year, 1 year's worth of rent. It was like 3-4 years of rent. On the 3-day notice, I put $6,000 on the 3-day notice. During the jury trial, the jury answered the question. They answered two separate questions. The first one was the amount owed not more than the actual, was the amount on the 3-day notice not more than the actual amount owed? The other question that they answered was, what was the total amount of unpaid rent owed during the last 1 year, from the year that the 3-day notice was served, going back 1 year? They answered 5,500, even though the 3-day notice said 6,000. And they've appealed because the judge entered judgment in my favor. But now they've appealed it and said that given the fact that the jury answered the question, what was the amount of unpaid rent due and owed in the 1 year preceding the service of the 3-day notice, the amount being $5,500, even though the 3-day notice stated $6,000. They're appealing.
Yeah, I'm
What are
not
your
sure
thoughts?
why they answered that way, but let them appeal. There's no problem with that because when you appeal from the streets. And what I mean by that is you don't get to stay in the unit while there's an appeal going on. So you can go forward to get yourself a writ of possession, bring that over to the sheriff and have them evicted. The only exception to that would be if they file a motion to stay pending the appeal. And if the judge feels that they have a good shot at having the judgment overturned, he might grant that, but it's very unlikely that they would do that. So I wouldn't worry about an appeal except for maybe the expense of the appeal, but get your writ issued and send that over to the sheriff's office.
And Dennis, do you think they will, if the appellate courts overturn, will I have to give them possession back or not?
No, because you're going to rent it to somebody else in this interim period. So that's an impossibility. Once you have possession, you have possession.
Great. Thank you.
And thank you. We're going to move on to who I called on before, and I hope you're ready this time. And that is Tessie. I'm going to ask you to unmute yourself. Come on, Tessie. There you go.
Good evening, Dennis. How are you?
I am fine.
Thank you for taking I think I called. I have this tenant who gave me a 30-day notice, and that notice expires, I believe, May 19th.
I'm sorry. I'm having a little difficulty hear you. Can you speak up?
I said I have a tenant who gave me a 1-month notice expiring May 19th. Turns out I did not sign a new lease with them when we bought this property. So we're still working on the old lease from the former owner. And just recently, Section 8, this is a Section 8 tenant, said she could move out April 30th, which means just a 20-day. Do I have to give her her security deposit back if I don't get a 30-day notice? That's my question.
Okay. Well, you always have to account for a security deposit. And from a security deposit, you're allowed to deduct for any unusual wear and tear, cleaning, and any unpaid rent. If the tenant gives you 20 days notice, then technically the tenant is responsible for a full 30 days worth of rent. So the tenant, at least for his share, since this is Section 8, would have to pay his share of 10 days prorated.
Okay.
All right, good question. Glad I came back to you. And we're going to move on, since we have more time, to Lynette Austin. How are you?
I am doing good. I have an apartment building in unincorporated Whittier. And I need to sell the property, but the rents are low. Can I do cash for keys?
You can do a
Without
cash
going-
for keys on any rental anywhere, certainly in the state of California. In other words, it's going to inure to your benefit if you can be selling this property with vacant units so that the new owner would be able to raise the rent to market level.
Right.
So, I mean, depending on what you could get for the building if the premises are occupied versus what you could get for the building if the units were vacated, that's a lot of play for you. And you could offer these tenants a substantial amount of money, assuming you can get them to agree.
Yeah, I think I can get most of them to agree, because it's in South Whittier.
Now,
So
you
when I'm
need to
preparing to offer them, I think most of them will take it and run.
Now, unincorporated areas of LA County where your building is located has specific rules and disclosure statements and special ways. So I would recommend following the law, or another way to do it is just call my office and we'll take care of that.
Okay, so even if I do cash for keys, I need to follow some
Yes,
guidelines.
there are certain guidelines, correct?
Okay, got it. Thank you.
Thank you. And we'll take one last call. James Rutowski, how are you? James, are you there?
Yes, sir. Do you hear me okay?
I do. How are you, sir?
Lovely. I work for an eviction attorney in Northern California, which he's essentially a carbon copy of you, but he's in San Francisco. And I've been a ghostwriter for AOA. I know you're a big fan of theirs, on his behalf. And the topic that he threw out, my next article, is mold is gold. Meaning that, testing, contractors, attorneys, mold is gold. So I'm wondering if you could provide a little bit of a soliloquy about mold. We have an industry partner here, Berkeley Property Owners Association, which states that mold testing is pretty much useless. The California Department of Health, in fact, she cited, says that they can't detect anything. So I'm wondering if, number one, if you have any soliloquy on mold.
Okay, well, first of all, it's the new sport in California is to sue landlords for uninhabitable conditions, and that usually refers to mold. I disagree that mold testing doesn't show mold. Testing absolutely does show mold if mold exists, and you always want to, at the first instance of a tenant complaining about a potential mold or a water leak, is to get yourself a qualified remediation mold company to go in to test. And then if it is unsafe levels, that you need to take care of that immediately, do the remediation. Because landlords, we've got three lawsuits that came in just this week from landlords being sued by these renegade attorneys that are just looking for cases and suing landlords for uninhabitable conditions. So, and I had some blowback as I talked to a client today at the office who said, "Well, let me just offer the tenant cash for keys to get rid of them instead of going through all this mold stuff." And I cautioned him that that's just a formula for disaster, and you're looking at a lawsuit. So whenever you have a situation where a tenant is complaining about potential mold, don't guess. Get yourself a company to go in there, test, and this way you're kind of shielding yourself from any lawsuits. And with that, we are over our time. So I want to thank all the people who make this show by joining us on the Zoom meeting. And also for those people watching on YouTube, please again, like the show and also subscribe to the channel. And all I can say as I end this show is go Lakers tomorrow. Have a good day, everybody.